and we welcome you to our webinar today. And we do want to let you know, just some housekeeping to start out with. We will have a question and answer session at the end of the presentation. Feel free to type your questions in the appropriate box and press send so we can get that. And we welcome all of our clients and partners and other employers who have joined us today. Compliance has become as important as ever, I think, with the Affordable Care Act getting most of the attention. But employers need to pay as much attention to their responsibilities under ERISA. And people may ask why. Well, the simple answer is that has to do with the Department of Labor and their auditing power. Over the past few years, we have seen an increase in the Department of Labor audits of employer plans. They're looking for compliance with both the Affordable Care Act, or ACA, and ERISA, which was passed back in 1974. The government has issued penalties recently in the $10,000 to $18,000 range for simply failing to provide a summary plan description in a timely manner. And we'll be talking about summary plan descriptions a lot today. Think of the impact that an audit would have on your business, just collecting all the information and the time spent with auditors. So what causes an audit? Well, the most common trigger is an unhappy employee. Also, the Department of Labor has national enforcement priorities, and one you see listed there, their Health Benefits Security Project, is the one that I think is going to cause most issues because this is the plan that is looking to make sure that you're complying with the Affordable Care Act mandates to your documents. If you have fewer than 100 participants, you may be exempt from filing a Form 5500, but if you're over 100, they're also looking for consistency in that document. So those things can trigger an audit in general. So how do you minimize the negative results of an audit? Well, the most important thing is having updated documents. That's the key. And then demonstrating that documents were provided when you needed to provide them. And of course, you want to reply to any employee's benefit questions and requests in a reasonable time frame to avoid an employee contacting the Department of Labor with a complaint, which again will get an audit going more often than not. Speaking of documentation, it's come to our attention that many employers that we talk to do not have perhaps the most important document for health and welfare plans, the summary plan description, or SPD. I found that there are two primary misconceptions about SPDs. Many think that they're too small to be required to have one. In reality, nearly every employer providing benefits needs to have one. Besides governmental agencies and churches, every benefit plan is covered under ERISA. If you have an owner and an employee, that makes a group. And it doesn't matter if you are a for-profit or a non-profit company. The other misconception is that the certificate or booklet issued by an insurance company is an SPD. In most cases, it is not. The insurance company booklet generally describes the relationship between the insurance company and the employer. But you need a document that describes the relationship between you and your employees and meets the minimum standards of ERISA. Let's look at the type of information required for SPDs. In most health and welfare SPDs, the employer serves as the sponsor and the administrator and the fiduciary. You have to assign a plan number and list, again, any fiduciaries or trustees that are outside of the employer. Your plan year does not have to coincide with the insurance policy year. Insurance companies use plan years and policy years interchangeably, but you can have one SPD with a common plan year and have insurance contracts with different policy years. The employer is usually the agent for legal process. When we talk about type of administration, it means whether it's administered by contract, insurer, or sponsor. And you need to list the sponsor's right to make changes and terminate the plan. In essence, this document gives the employees the rules of the road for how the plan can change. And most importantly, it provides information on procedures, claims, subrogation, coordination of benefits. The ERISA Statement of Rights is extremely important. It's also how cost sharing is based. Also, it has to cover topics like control group, collective bargaining groups, compliance with COBRA, HIPAA, and other mandates. It has to indicate whether it's insured or self-insured. Having an SPD wrapped with the certificates can make the document together serve as both the summary plan description and the plan document, reducing the chance of a dispute with that employee who might complain to the DOL. So having the proper documentation is extremely important to insulate yourself from the penalties that you could face with the Department of Labor audit. Now, when must you provide SPDs? You can see the list here. The second bullet point, we found that with many employers not having an SPD, they fail to provide one within 90 days of a participant, in this case employees, enrolling in the plan. You certainly have to restate it every 5 years if material modifications, meaning amendments, changes to the plans have been made. And every 10 years, if no changes have happened. And if the Department of Labor asks you for one, you need to provide it within 30 days. There are, as you can see here, civil penalties up to $110 a day, and criminal penalties could apply in some cases. So how can you provide SPDs once you have one? Mail is accepted. You can see there are several different options to provide it. And you can provide it electronically to your employees if you follow the Department of Labor Safe Harbor guidelines, which basically is that you assume that all your employees have reasonable access to a computer. Now, you don't have to redo an SPD every time you make a change in your benefit plan. You can issue what's called a summary of material modifications, which just simply lists what the changes are. There is no ERISA format for this. It has to be, as you can see, provided within 210 days after the close of the plan year. And this has to be issued if you're materially reducing benefits, drastically reducing them within 60 days from adoption. Now, here's an area where ERISA and the Affordable Care Act kind of are in conflict because the Affordable Care Act requires that the document that their act created, called a Summary of Benefits and Coverage, be provided 60 days before any mid-year plan change. In other words, any change that didn't occur at renewal time. So it's important to keep that in mind as well. So let's talk about that document. It was established by the Affordable Care Act to standardize information so that individuals could more easily compare different plans. Sort of like going to the grocery store and looking at the chart at the back of the box of the can among your groceries. That was the intent. And the template was developed by the 3 regulatory agencies that are in charge of enforcement of the Affordable Care Act: Departments of Labor, Health and Human Services, and Treasury, so that every plan has to follow this template. And it includes a lot of things: uniform definitions. It describes the coverage, and the more recent versions of it indicate for the employee whether the plan provides minimum essential coverage and minimum value requirements. Of course, this is very important for both the individual mandate, you have minimum essential coverage, and then the minimum value requirement for the employer mandate. And the penalties are fairly stiff for not complying, up to $1,000 for each willful failure. And there's also an excise tax that could be triggered. The government is making changes to the summary benefits coverage, and this will take effect beginning with open enrollments in September. The objective is to make it a shorter document, but although they're adding a third claim example. Right now there are 2 on it, and the wording will be revised to reflect the most recent changes caused by the Affordable Care Act and the market reforms. So we're happy to announce today that we have a compliance program for employers where we will create or restate an ERISA compliant summary plan description and document. It will contain all the necessary language and notices for your health and welfare plans, including the Newborn and Mothers Health Protection Act, Women's Health and Cancer Rights, and a few others. We will provide or review for accuracy the summary material modifications, those amendments to SPDs as plans go on, summary of benefits and coverage, both for the enrollment and also for any 60-day mid-year notices, plus the exchange notice. We've noticed that a lot of employers are not aware of their obligation to tell all their employees when they're hired about they have the right to go to an exchange and such. Many think it's an annual disclosure, like the Medicare Part D disclosure, but it actually needs to be in your packet, your new hire packet. We'll also provide you guidance on what documentation needs to be maintained through a Department of Labor audit, and also remind you of those compliance deadlines. The service is designed to ensure that you have the proper documentation provided at the appropriate time and prepared in the event that the Department of Labor comes knocking at your door. Of course, in truth, actually, a Department of Labor audit starts with a long letter, not a door knock typically. So what will this cost? We've priced this at $600 for the first year for the plan document, with annual reviews costing $125. However, we've deeply discounted this for our clients. First year fee is $250 and an annual review fee of $75. The first step is to contact us, and we certainly will be reaching out to all of our clients. We're opening this up to employers of all sizes, since about every employer needs, among other things, a compliant, updated SPD. Now we'll be, and in summary, the government is increasing their efforts to audit plans for compliance. They'll be looking for ERISA compliance as well, and we can assist you in making sure you have that appropriate SPD, reviewing your other documents, and developing a paper trail for your efforts to be in compliance. With that, that concludes our webinar. We're happy to take any questions you might have. Some might be very specific to your situation, and we can certainly handle offline. And appreciate your time this morning to review these facts.
Okay, the first question, you quickly mentioned that churches and the SPD. What was that? Also, will your PowerPoint be available to copy?
2 very good points. Answer the second one first. There will be a copy of the PowerPoint emailed to all participants, and along with the answers to our question and answer session now. And there will also be a webinar replay available for you. Regarding the first question, what I meant to say slower was that the government agencies and church plans are exempt from ERISA. Therefore, they're exempt from preparing a summary plan description. All other employers are subject to the ERISA requirements that require the SPD.
The next question, do part-time people need to be given information of coverage?
Another good question. No, the SPD is just for those who are eligible for benefits. Now, obviously, if your part-time employees have some for providing benefits to them, you can either provide the full SPD or a narrowed-down version that just applies to the benefits that they're able to be eligible for. So it depends on your own situation.
The next question. I am new to my small company and I'm trying to locate our SPD. Should my broker have a copy of this?
Again, another good question. As we've said before, we found that many employers don't have an SPD for their health and welfare plans. Mostly everybody has an SPD for their qualified benefits programs, pensions, 401ks, and such, which this is not involved with. But you should have one on file. It's an employer responsibility to provide it. So I'm guessing that if you don't have one, if you can't find one, you more likely don't have one. But of course, it is possible that your broker would have a copy, or more likely your attorney would have a copy. Whoever takes care of your regulatory requirements.
Next question. Can you place an SPD into an employee's mail bin? Is this considered sufficient delivery of the document?
It's a very good question. Let me get back to you on the actual mail bin part of it. It has to be a written document so that it qualifies as that. But let me get back to you on specifically whether or not mail bin qualifies versus regular mail or handing it to them in person.
The next question, just because your employer is a church, does it mean you have a church plan?
If you're covered under Section 501, then that would be a church plan and exempt from ERISA. So you need to check how what your legal status is with your attorney or other legal advisors. Very good questions this morning.
Do we have any more questions? The next question, can you post an SPD in a communal area such as a lunchroom?
No.
The next question, we have a number of part-time employees. Some are strictly 20 hours a week, but some are working between 30 to 35 hours a week. Are these people considered eligible for health care benefits?
Another good question, and really one that we'll we have to look into specific facts of how what your status, how you're classifying those employees. If they're variable hour employees in their measurement period, you're not required to provide the SPD because they're not eligible participants. So sort of the answer to your question depends on how you define eligibility, which would determine whether they need to provide documentation or not. So we'd be happy to talk to you offline about specifics.
The next question, is making an SPD available on an employee internet self-service portal sufficient delivery?
Yes. Again, if you meet the requirements of the Department of Labor guidelines, the Safe Harbor guidelines for electronic delivery, the answer would be yes. Any more questions this morning? Of course, we're available to take anyone's questions and certainly get involved with preparing SPDs.
We do have another question.
Okay.
Where can we find the Department of Labor guidelines?
Well, they have a website, and we can certainly send that out with our email. That will, you'll have that information there. Probably the best source. And we can provide information if you provide your contact info on our information on that area. Well, time to wrap it up. I think I appreciate everyone's time this morning for this brief webinar. Look forward to sending out the PowerPoint presentation, and look forward to working with many of you to have the proper documentation so that you're prepared if the Department of Labor does decide to come knocking at your door. Thanks for your time this morning.